welcome to Legal Aid Queensland's webinar, The Basic Laws of Bankruptcy. My name is Catherine Bowden and I'm the Communication and Community Legal Education Officer here at Legal Aid Queensland. I'm just going to go over a few logistics before we get into the presentation. Could you please raise your hand if your technology is all working? Okay, great, thank you. I can see a few hands raised there. I'll just show you where the handouts are for today. So the right-hand toolbox, you'll see the handouts section. We've got the LAQ QPILCH, the Basic Law of Bankruptcy handout, and below that we have the PowerPoint slides. So if you'd like to download those and take them away with you, that could be helpful later. Okay, now I'm just going to run a quick poll. The question is, do you work in a rural, regional or remote area? If you can take a minute to answer that, that would be brilliant. While we're going over the poll, I'll just tell you about the setup today. So it's going to run a bit differently to normal. It will be more conversational. We have two presenters. We've got Paul Holmes, our senior lawyer here in our Civil Justice Services team at Legal Aid. And we also have a guest presenter, Elizabeth Gallagher, who's a solicitor at the Queensland Public Interest Law Clearinghouse, otherwise known as QPILCH. Got a few more people to vote. So the first half of our presentation today will be the presentation time, followed by about 20 minutes for questions. If you can just hold your questions until the end, that would be great. Once we call for them, you'll see the questions box, and if you type those in there, we'll try our best to get through them. Any questions that we don't get through, you'll be able to email us, and the email address is webinars, WEBINARS, @legalAid.qld.gov.au. Okay, so we've had 47% of you have said yes, you do live or work in a rural, regional, remote area. Sorry, that's just changed to 45%, and 55% of you are in the metro area. Okay, I'm now going to hand you over to Elizabeth and Paul to start off the basic laws of bankruptcy.
All right, welcome everybody to the basic laws of bankruptcy. So the plan today is to give you guys, I guess, the overview to what bankruptcy is, how it operates, so that we can have a conversation with the questions at the end as to what the more difficult stuff you guys probably see with clients, with a view to then maybe doing other bankruptcy seminars on sort of more intermediate and complex areas of bankruptcy later in the year. So welcome, and I'll get us started. So for those of you who've not seen bankruptcy before or not dealt with it much, what we're talking about is it's the legal process whereby people who are insolvent have their affairs controlled. It's not dealing with corporations. Bankruptcy just deals with individuals who are unable to pay their debts. As you see in the slides, when we're talking about corporations, it's more about the corporation being wound up or placed into liquidation. The law we're dealing with is the Bankruptcy Act from 1966. And it's got a number of what I think are really important purposes. Primarily amongst those is about a fair and equitable distribution of the debtor's estate. So in the sense of, if they've only got a little bit of money, how do we fairly divide that up between all of their creditors? It allows people whose finances are just so hopeless or unable to be controlled the ability to, in a sense, start again, but without neglecting their obligations to their existing creditors, to allow people to oversee the bankrupt estate, and to provide a benefit to the community by restricting the activities of people who have no money and are in an insolvent position that they can't recover from. So what we propose to do is head through the various options when it comes to bankruptcy, from people going bankrupt themselves to creditors deciding to make people bankrupt, and then look at what other options people might have. So let's start with the idea of voluntary bankruptcy. So when we're dealing with voluntary bankruptcy, what that means is the creditor decides this is all too much. Sorry, the debtor decides this is all too much for me. I'm going to go bankrupt myself. And so what they would need to do in those circumstances is lodge what's called a debtor's petition in court. And at that point in time, the official receiver, or what's now known as AFSA, the Australian Financial Security Authority, try saying that fast 3 times, has the ability to look at it and make a decision as to whether they think that's a good idea or not for the person to go bankrupt. And examples where people might have that petition rejected is, I've seen, for example, people try and go bankrupt on a $300 debt when they've already got $1,000 in the bank that they could be using to pay the debt. So that's not a good idea when it comes to going bankrupt. Other examples of that we see where people might go bankrupt on a little bit of money or owing a little bit of money, try and get out of the bankruptcy, but find themselves unable to pay the trustee's fees. And that's probably one of the things people least understand about bankruptcy, the fact that when you go bankrupt, the trustee actually gets paid, and they often get paid a bit of money, don't they?
Don't they, Liz? Priority.
Priority? So priority in what sense, Liz?
In that they'll get paid before creditors, usually.
And that makes it difficult when you see people trying to get 10, 15 grand to pay the trustee, which is often what they can charge. You see some trustees able to charge $500, $600 an hour to manage a person's estate. So
that's because I think there's private and public trustees. So there's a lot of companies that's their business, but there's also the official receiver acts as a trustee for a lot of people. So the fees can differ.
And it's probably in the type of clients we see is interest in a lot of ways to have the official trustee, the official receiver as their trustee, as opposed to anybody else. And then I guess the thing is, if the bankruptcy is accepted, what happens then is there's a statement of financial affairs that the person has to fill out. But what's worth exploring really quickly, and we'll go into this in a bit of depth later on, is this idea that there are often other options. One is a Part 9 debt agreement. Sometimes that's a good idea and sometimes that's not, and we'll explore why later. Negotiating hardship arrangements on debts are often really important. Hardship, when it comes to creditors, whether it be banks, debt collectors, finance companies, have come a really, really long way in the last 10 or 15 years. And they're certainly a lot more willing to listen to arguments about people being in hardship and needing more time to pay debts off than they were, say, in the 80s or 90s. So it's worth at least exploring that. And then finally, there is also the option of letting the creditor take you to court. In some circumstances, that can end up in the creditor wanting to bankrupt a client anyway, but it's an avenue worth exploring. So, let's talk about involuntary bankruptcy.
Yeah, so as Paul's mentioned, that's when a debtor has not chosen the process, but a creditor chooses to take that action. So an involuntary bankruptcy will always be in either the Federal Court or the Federal Circuit Court of Australia. They share jurisdiction. The Family Court also has some jurisdiction in this area if one of the parties is involved in family law proceedings, so there can be some crossover there. So there's threshold requirements that a creditor must be able to meet to be able to take this action. There has to be things in place. So firstly, the debt has to be currently due and payable. It can't be stayed. And that might sound like an easy thing to say, but there's some things out there that often stay debts without people realising. So that's things like instalment plans they might have applied for on a judgment debt. Some court rules say that you can't enforce cost orders until a certain point in the proceedings. So it's always worth exploring that just a little bit more if it's a judgment debt of some type, I think.
And does the debt often have to be $5,000 owing to one person, or can creditors combine the debts?
Creditors can combine, so they can bring a joint petition, it's called, and in addition, if one creditor brings what's called a creditor's petition in a court, another creditor can actually say, hey, I'm interested in that as well, and join as what's called a supporting creditor. And that makes it much harder to oppose the petition, even if there's a problem with that first debt of the first creditor. That supporting creditor can step in at any time and say, well, that's not going to work for them, but we're still wanting to bring this. So
that makes it really important that you deal with all of your creditors rather than just some of them.
Yeah, exactly. And that's important because anyone bringing a creditor's petition needs to show that the person that owes the money has committed what's called an act of bankruptcy. So that's defined very clearly in the Act as being a certain number of things. For example, if you get a warrant of possession for the possession of some property of a debtor and they can't action that for, so it's called getting returned unsatisfied, but basically a bailiff shows up, tries to take possession of the property and the debtor says it's gone now, that's an act of bankruptcy. So there's a certain set of things, but what that means in terms of supporting creditors, if that one creditor can prove an act of bankruptcy,
the others don't have to?
No, they can rely on that same act of bankruptcy.
Okay.
The main act of bankruptcy that I see in the courts anyway is what's called the failure to comply with the bankruptcy notice. So a bankruptcy notice isn't a court document, although all of our clients often mistake it as being a court document. It's actually something that's issued by the official receiver, or AFSA. But a bankruptcy notice has to be based on a final judgment or order of a court, which can include a costs order. It doesn't have to be the last judgment in a proceeding. And it basically says you have to pay me my debt within 21 days, and if you don't, there's a presumption then that person is insolvent, and the creditor has the power then to come to the Federal Circuit Court.
And so what's the consequence if they haven't done that notice properly?
Then there's no act of bankruptcy. So it's really technical area of law bankruptcy. We've listed on the slides sort of the four main areas, which are the court rules about this. There's many, many kind of requirements in all of those different acts. I've got two checklists, which are both, a A4 page with about 15 questions for a bankruptcy notice and a creditor's petition. So it's not as easy. It's always worth going and getting a bankruptcy notice or a creditor's petition checked by a legal advisor, because even if your client doesn't think that they want to dispute the debt, there might be a problem with the bankruptcy process that's being followed by the creditor.
Okay. So what options have we got?
Well, you can agree, well, you can do nothing, basically. That's always an option. As I said, though, always get everything checked, because it might be something wrong, something that the creditor hasn't done.
Because we've all encountered clients who do the ostrich and hope it'll go away.
Yeah.
These things don't ever go away, do they?
No, they don't. And even at a late stage like bankruptcy, you can go back and get a default judgment set aside or do other things that can get the debt removed effectively. So it's always worth getting some legal advice, I think, if it's in a court proceeding. But basically, you've got sort of two stages where you can respond. If there's a bankruptcy notice, you can set that aside, it's called, which means that you won't have committed an act of bankruptcy. But you can also oppose the court application, which is called a creditor's petition, and ask for the sequestration order, which is the order making someone bankrupt, not to be made. And you can bring in arguments about a bankruptcy notice at that later stage as well. So even if a person didn't get advice and they were served with the bankruptcy notice, if there was still a deficiency, there's still a chance to sort of bring that up in response to a creditor's petition.
Okay.
Yeah.
All right. Now we'll move to Part 9 debt agreements. And I'm sure most of you out there have seen the ads saying, effectively, we can make your debt go away. And often it's companies advertising the ability to put people into Part 9 debt agreements. So let's just explore what they are. And what is effectively you're admitting you're insolvent, but you're attempting to come to an agreement with your creditors outside being made bankrupt.
Yeah.
And it's really only available to debtors who are earning a lower level of income and have a lower level of debt. For example, if you're earning over the current threshold's 81, I think it's a tick over $81,500, you can't even consider entering a Part 9 debt agreement. If creditors agree to accept the sum of money you propose, they then can't take you to court. And if you successfully meet your Part 9 debt agreement, then any further obligations you would have had to pay debt at the end no longer apply because the debt's effectively discharged. The problem is the agreement will come to an end if a debtor defaults. Now, before I go into how it's made for a little bit, just explore the idea of, well, why would a debtor default? And the problem is, the whole idea of a Part 9 debt agreement is you're agreeing as a debtor to pay, let's say, $60 a fortnight for the next 4 years in order to discharge your debts. And that $60 a fortnight will get shared in a specific percentage between each of the creditors. The problem I see quite regularly with Part 9 debt agreements is for people who are on fixed income. So people who are on a pension or on a very low income that doesn't increase because it's a lower skilled job. The problem with that is people's expenses when it comes to food, rent, electricity, water,
pretty much everything.
Everything, yeah, I could go on for a while, continue to increase over time because that's, as we all experience that. The problem is people's income doesn't also increase to make account of that. So what we often see is people, when they enter into the debt agreement, are quite able to pay the $60 a fortnight, say, for the first year, if they get that far. But in year 2, with expenses going up and up and up, they can no longer afford to pay the debt agreement. And there are serious consequences to that. And the serious consequences to that is by the mere fact of even putting in a debt agreement
or a proposal for one.
A proposal for one.
Even if it's not accepted.
That's already an act of bankruptcy.
It is, yeah.
And the problem you've got there is that people in that scenario, if the creditors say, hang on, and we're looking at the slide here as how it's made, if the creditors look at your proposal and say, hang on, I don't want to accept this, and vote no, what would they do instead? And the answer to what they would do instead is they can proceed to file a creditor's petition. And the creditor's petition is what Liz covered earlier, that ends up with the client being made bankrupt anyway.
So it's not an easy fix. People have to, it's not a way to delay bankruptcy proceedings, basically. If you do it and it's not a genuine proposal or it's not one that's going to be accepted, then you're really just speeding up the process for your creditors in the end. Particularly
when, and I think we've both seen clients who want to put forward Part 9 debt proposals where they pay $5 a fortnight to all their creditors. Wouldn't even bother.
So it really has to be a commercial offer, I guess, is something to think about. What will the creditors even accept?
Because if it's not going to see them get any more than, say, 5% of what's owed to them across the 4 years, it's not in their commercial interest to accept, and they're more likely to get money out of the client by making them bankrupt. So it's really key that people realise, and people don't necessarily believe some of the advertising that portrays Part 9s as an easy fix. It's, in reality, probably as serious as bankruptcy and ends up with a lot of the same consequences. And it's really important that people are aware of that.
Do you see many clients, Paul, who get confused about the difference between a consolidated loan and a debt agreement?
And a Part 9, yeah.
With a private company?
Yeah, and this is one of the really difficult things to untangle sometimes, because some of the advertising you see talks about consolidating loans, and that's where the company will try and refinance, say, people's credit cards, their mortgage, their car loan, all into one loan.
With that company?
With that
or
one,
a friend of theirs?
With that company, or often a company that's closely connected to them. Or what they're actually proposing is a Part 9. And we see plenty of clients that confuse the two and think what they've actually got is a consolidated loan, when what actually has happened is they're a hair's breadth away from being bankrupt, particularly when clients in that financial position often are lurching from crisis to crisis, and it's only a matter of time before they're wanting to seek hardship on the loan. And you can't seek hardship very easily on a Part 9 debt agreement. Now, consequences of bankruptcy.
Many.
Yeah. We talked about the trustee earlier. People forget that there's a trustee.
And that the trustee's job is to act in the best interests of creditors. they're not someone that's on the debtor's side as it is. Yeah.
Despite managing their financial affairs. Your credit ratings history for 5 years. The other thing people don't understand is there's actually a register that I think it started 1 January 1901, I think, when Australia became a separate country from England, that lists everybody that's ever been bankrupt since 1901 in Australia. And occasionally companies check that. So even if your credit rating comes good again after the 5 years, people will often still look at that register. Trustee makes major financial decisions. However, if you've chosen to go bankrupt, you do have some control in the sense that not all debts have to be included in bankruptcy.
Yeah, if a creditor makes someone bankrupt, the creditor gets to choose the trustee generally as well, something to be aware of.
Which is really important because you often end up, I guess, with private trustees in that circumstance.
With higher fees. Yeah.
Which makes it difficult as well.
And there's often, well, the complaint I hear a lot is that then that private trustee is too close to the creditors in a way. There's a big perception of bias, which might not be
necessarily true.
No, but it makes it much harder for the debtor, I think, to get through the process.
Because they feel like there's nobody supporting them. And the reality is, when you've gone bankrupt, you have lost control.
Yeah.
And that's a hard thing for people to understand. Now, on terms of the obligations, they're fairly standard in the sense that if the trustee asks you for something,
you've got to do it, mostly.
Pretty much, because like we said before in the earlier slide, they now have control of your financial affairs. If you're making a major financial decision, it's pretty much them that make it.
Yeah, and the obligations are ongoing in terms of disclosure, as in telling the trustee everything about your financial position, when you want to change jobs, when you want to go overseas,
and that
lots of things.
That can become really hard in a relationship sense, can't it? Because sometimes one person to the relationship might have gone bankrupt, the other one hasn't.
Yeah.
And you might have joint properties like a house.
Yeah.
And that people who aren't bankrupt in that situation can often find that really difficult.
Yes.
Because let's say, what happens if the trustee decides they want to sell the bankrupt's half interest in the house?
Well, the trustee automatically becomes an owner as a tenant in common. So.
And does that get changed on the title?
Once they register their interest.
Yeah.
And so they can force the sale even if the other person doesn't agree. And there's really very little defences that can be raised to an application of that type. So, excuse me. So a partner that jointly owns property has very little control unless they're in a financial position to buy out the trustee's interest.
And the reality is that very rarely happens.
Not a lot of families that have that money hanging around.
No.
Or that would get a loan off the sole income, really.
Really, to be able to buy that half interest. So is it often in the interest of the non-bankrupt in that scenario to ensure the whole of the property is getting sold rather than just the interest of the bankrupt?
Well, the whole property will be sold because you can't sell a half share in a house.
Well,
unless
sometimes you can, if depending, but
it would be an odd situation, I think, if someone else moved into the other half of your house. So it wouldn't be the practice.
It's not the norm,
no,
but unfortunately, I have seen it happen to people.
That'd be interesting. I think what the trustee usually tries to do is force the sale of the whole property.
Yep.
And so everyone has to move out effectively. And because one partner's bankrupt, that can make rentals difficult, all sorts of things in terms of getting bonds together and bond loans. So it can have a roll-on effect in terms of someone's living arrangements.
And that's a really important point, I think, too, that people don't explore very often, and that's that rental issue. There's nothing actually in the law that says it should be more difficult for people to rent when they go bankrupt, but
in practicality, it's
much more difficult.
Real estate agents are more readily doing credit checks and things like that nowadays, so the bankruptcy will be flagged and could become a real issue.
Yeah. And then the final thing that's also worth exploring is this idea that you're going to be required to tell people that you're bankrupt in pretty much every circumstance.
Yeah.
There is a small threshold below which you don't have to tell people if you're seeking credit that you're a bankrupt, and it's in the region of about $5,000.
It is. So things like those furniture rentals might be okay, but they're not good deals generally anyway. So what sort of pushes bankrupt into that scope of credit where there's not good lending options and things like that?
Or more expensive lending options, because if you, let's face it, if you've just been kicked out of your house, you might not have all the essentials you need to move into a rental accommodation, and that makes it difficult as well. So in terms of, I think, the broad brush type stuff about bankruptcy, hopefully that gives you a starting point idea. What we also wanted to highlight with you is there are contact details up on that last slide, and I think we're both happy for people, if you've got questions or you think somebody would benefit from getting legal advice from either of us, drop us an email, and we're generally pretty good at replying unless we're in court or out of the office, and we can, even if it's just we look at it and go, look, there's nothing you can do, probably no point, or yes, there is. We welcome those queries, we welcome those phone calls, because that's the best way of clients getting the best advice possible.
Yeah, definitely.
And we think that's really important, because often people think about bankruptcy, hang on, there's nothing I can do, there's no other options. Or in some cases they say, hang on, I just don't want to deal with the debt collectors anymore, or I just don't want to deal with my creditors anymore, and they just go that way. I think if nothing else gets taken away from this, it's worth at least looking at it.
Yeah.
And it's worth at least looking at the other options that people have.
I think Paul's expertise is very broad, but he'd be better placed to do things about debtors' petitions.
Yep.
Whereas I have a bit more expertise in the court sort of based things that go on.
Yep, and I think that's right. And so please seek us out if you need that sort of help. Now, that leads us to I suspect some of you have been waiting for, which is the opportunity to answer questions. Ask questions and get us to answer them. So Catherine explained getting access to the question box. We would welcome any questions that you guys have got. And an early one we've got is to do with rental arrears. And the question was around of what happens to rental arrears if somebody goes bankrupt, and what happens to the ticker database, which I guess is really important to that rental question we were talking about before. So I guess the first question is, can you go bankrupt on rental arrears?
If it's over $5,000, yes.
Or if you're doing it yourself,
yes,
you could go bankrupt on that. Does that stop you being listed on the ticker database though?
I don't think it does.
No, well, because it's still an ability or a debt that people are owing, and it's something that they can list on the database, and that makes it difficult, I acknowledge, for people to rent, but unfortunately that's not something that stops them listing.
Yeah.
However, it's worth noting that there are procedures if you feel a client has been improperly listed on the ticker database that involves bringing a QCAT application.
And it's worth knowing there's a 6-month time limit on that application from when the person becomes aware of the improper listing, as it's alleged. So Tenants Queensland has a pretty good fact sheet on ticker listings, like when someone can be listed.
Yep.
But basically our answer is that it's the debt meets those requirements on its face. The only thing that a creditor might have to do in that circumstance is make sure the listing is accurate. So if the legal effect of the bankruptcy is that that debt is satisfied. So the ticker listing should be updated to show that the debt has been satisfied.
Yep.
So it's worth making sure that the listing says that, because that can make it a bit more attractive. It's not good the person ended up there, but it shows in some ways that the debt's been taken care of.
All right. So we've got some other questions coming through. So one of them is around this idea of what happens if there's joint owners and negative equity, and what happens to the person in that scenario who's not bankrupt. And that's probably more a practical question than anything.
So my understanding is that if the loan is higher than the amount of the value of the property, I should say, it's probably unlikely the trustee will sell that asset. That's called realising an asset. So if the trustee is not going to get any benefit, or the estate's not going to get any benefit from an asset being realised, the trustee is unlikely to sell the property as long as the mortgagee or the mortgagor
the mortgagor
is happy to maintain that loan.
And that's probably the more pertinent question there, because it's often not the trustee that sells people up in those circumstances. It's often the bank or the finance provider who hasn't had their mortgage paid that's more likely to look at selling it to try and realise some money out of that property, rather than little or none at all. And of course the risk there is that if they sell the property and there's still a shortfall owing,
and that happens after the date of bankruptcy, that debt probably is not going to be included in the bankruptcy.
Which means they can come after not only the person who's not bankrupt for it,
but the bankrupt becomes a new debt.
And that's something people don't readily understand in my experience.
So once you enter bankruptcy, it's from anything owed on that date backwards that's kind of taken care of, aside from the excluded types of things, which are things like fines and debts owed to the government as a very general kind of group of things. But any debts the person accrues going forward from the date of bankruptcy do not get encompassed in that bankruptcy.
Yes. All right. Now there's another question. This is one of those more difficult questions that we sometimes get. And so the question relates to what happens if you want to go bankrupt on a secured debt when you no longer have the asset in your possession. The example being it might be in a storage lot, or it could be, say, in a mechanics repair shop, somewhere like that. Now, there's nothing stopping you going bankrupt on secured debts, is there?
With involuntary bankruptcies, there's a little bit of a
wrinkle.
technicality.
Thought there was.
So with the $5,000 threshold for involuntary bankruptcies, if a creditor is a secured creditor, they have to show that the value of their security leaves a $5,000 gap in what they're owed. So say the debt is $10,000 and they have a $5,000 security, then they can make the person bankrupt because the difference between what they're owed and their security meets the minimum threshold. But if the property was worth $7,000, they'd only have a gap of $3,000, so that would not meet the threshold requirements to make someone or bring a creditor's petition. However, a creditor can forfeit their security. So they can come to the Federal Circuit Court and say, I forfeit my security for the benefit of all creditors, and I'm now bringing this petition.
And how often does that happen?
I've seen it happen a fair bit, particularly if it's known that their security is probably worthless anyway.
An example of that's probably, say, for example, the client's had their car involved in a car accident, has no insurance, and can't afford to fix it. Is that the sort of thing you're talking about?
Basically.
Okay.
Or if there's a property that has no equity.
Okay, and then they're thinking that they might get some money out of it that way.
Yeah.
Okay.
So, I mean, it's a pretty serious step for a creditor to take, but they do it. What's the impact on voluntary bankruptcy?
Well, I guess the thing with voluntary bankruptcy is while there's not a crystallisation of the loss, you'd probably question whether it's worth doing, in the sense of, fair enough, you can't afford to pay it. That's what hardship's there for.
Yeah.
And you'd be making a hardship application to the company involved to say, hang on, I've been unemployed, I haven't been able to pay it, but I'm about to get a job and I should be able to pay it. And that's a better option than going bankrupt on it, because you're not then in a position where you're taking that decision out of your hands, in a sense.
And it ties in a little bit with the last question, but I'll also sort of say that sorry, I've lost my train of thought.
No, that's all right. We'll go back to the secured debt idea, and this idea that...
Oh, sorry.
No, you got it?
Going into bankruptcy can be a breach of a lot of loans. So even if a mortgage or a secured loan is up to date, it can be a breach of your contract by entering bankruptcy. So often a secured creditor will be given an election about whether they want to be involved as a creditor in the bankruptcy, or if they want their contract to continue because they feel confident that the debtor will kind of meet their obligations.
And the reality, and from what I see, is most creditors in that circumstance will take the secured asset, sell it, work out whether they've then got money still owing on the debt, and will often maybe try and include the shortfall debt in the bankruptcy rather than including the secured debt, which I guess has a lot a little bit more uncertainty in it in terms of what it is they think the debtor will ultimately owe them, which is really important to consider. Now, there's another question. Please keep the questions coming through. I suspect there are questions too complicated, but you're welcome to try them and see just what trips us up. Another question that's come through is it worth both a husband and wife going bankrupt? And I assume that the implied part of that question is at the same time, or having a wife going bankrupt or a husband going bankrupt after the other partner has gone bankrupt. So there's probably a few considerations we need to think about there.
I guess the first answer is there's no need for a partner to go bankrupt just because the other person is.
Yeah.
It's about everyone's financial position as a whole. It's worth noting that a trustee has powers to go back about 5 years at least to look at transactions that have passed from the bankrupt to anybody else. And if they feel that those have been divesting, the bankrupt of any assets, they'll try and recover that money.
So hypothetically, say if the wife came into 4 or 5 properties that the husband used to own, do you think trustee would be unhappy with that?
Yeah. So there's no way to protect a person by getting rid of their money and giving it to the husband or the wife. But if the financial position as a whole, makes bankruptcy a good idea, then the one benefit I know of those 2 people going bankrupt at the same time is that they often administer the estates together. So the whole process will run
maybe a bit more smoothly.
1 meeting instead of 2 meetings, and all of those sorts of things are a bit more straightforward.
Okay. I guess the other consideration there too, though, when you're considering bankruptcy for both people involved in a relationship, is how many of the debts are actually joint debts. Because often what you see is sometimes people might have brought existing debts to the relationship which are just in their name. And the question there is, if they're just in their name and the other person might only have 1 or 2 debts that they could afford to pay, then it's probably not a good idea. Where that goes a little bit wrong, though, is let's say people have brought debts to the relationship and there's a joint property that's been brought. It's not out of the realms of possibility for a creditor who has a debt in one person's name only to go to court, get a judgment, and then seek an order to have the jointly owned property, say whether it be a house or a car or caravan is another big one, sold in order to get that money that they're owed from one of the partnership out that way. And that often comes as a shock to people, that a house or a car can be sold effectively to pay what was originally maybe a $1,000 credit card debt or a $2,000 personal loan.
Interest counts, like it accrues towards
the amount as well.
Yeah.
So that's also really another important consideration. So I guess the ultimate answer to that question is it's going to depend on the circumstances, and it's probably yet another reason for a conversation with lawyers before those sort of decisions are made, because it's really going to be in individual circumstances as to what that best option is.
And it could help the family, if there's no need for both to be bankrupt, to have one non-bankrupt party.
Because then they can be the name on the rental, as an example.
Exactly. It can make practicalities a lot more easier, obviously.
Rental, they might have
electricity, not having to pay a bond for gas and all of those sorts of accounts.
Which are all expenses when you're bankrupt that people can't usually afford to pay.
Yeah.
Okay, and so feel free to keep those questions coming through. Another one that's come in is a question along the lines of, okay, I've got a creditor's petition. I think I can pay the money, but I need more time.
Don't tell the court that.
Don't tell the court.
It's fine too.
What happens when you tell the court that?
They go, oh, you mean you're insolvent? Okay, I'm going to grant the petition.
So that's a slight problem. So rather than telling the court that,
you can engage in what's called without prejudice or confidential discussions with the other side where you're making an offer out of court. But as far as the court's aware, you need to put in something that looks like a legal ground to oppose the petition. There's very set grounds on legally what you can do to stop a creditor's petition happening. In the handout I've linked some of the resources, some fact sheets I've got which set out those grounds. But effectively you need to put something into the court to try and get more time without telling them that's your purpose.
Okay.
because the court, its power or its job under the Bankruptcy Act is to do those things that Paul said out at the beginning, and one of those big things is to protect the public. It's not a debt collection proceeding. It's a proceeding about the solvency of that person. And once the petition is filed, the court, there's a rule that says even if the creditor wants to withdraw it, the court has to approve that. So the court's on the lookout for the wider financial circumstances of the debtor. They're not going to accept the fact that the creditor's gotten paid by a loan, because that will make the court question, well, what about this person's other creditors? Why should I let you go into more debt to pay another debt? So they're pretty active in deciding when they're going to let someone off the hook, as it were.
Okay.
Yeah.
Can you maybe in effect take that decision away from them, say by, let's say you owe $5,500 on the creditor's petition,
Mm-hmm.
and you got to spare $600 cash. Is that done often, where you reduce the debt to below the involuntary threshold?
Yeah, a lot of people do that. It is technically relevant. So the creditor has to prove, one, that at the time the act of bankruptcy was committed, $5,000 was owed. At the time they filed, $5,000 was owed. And at the time of the hearing, that $5,000 is owed. So there's a bunch of steps where you can, if you can break that chain, I suppose.
And reduce your debt below $5,000. Okay. Practically though, is that likely to work? Because in a sense, interest is included. Let's say you reduce it below to $4,900.
Yeah, interest is included pre-judgment.
Yep.
So post-judgment interest is not included in the threshold amount.
Yes.
Yeah. The things to look out for there are often supporting creditors.
We'll jump in.
Yeah. But, you know, if you can bring the debt below $5,000, there's no one else around, the creditor can't prove what they need to prove.
And that opens up possibilities for hardship negotiations.
Mm-hmm.
If the creditor is not playing with you and they're a financial institution, it might offer opportunities to go into the Financial Ombudsman Service or the Credit Ombudsman Service.
And if the petition's dismissed because they haven't met the requirements, there might not be an order for costs. I say might because if the creditor gives evidence to say, I bought this petition and then they paid me $600, the court might be persuaded that the creditor's entitled to the legal costs they expended. And then that might make a debt that then again is more than $5,000. So it could just be a delaying tactic in the end, but it is sometimes just by getting a petition dismissed and putting the creditor to some costs, you do prompt them to enter into negotiations because they think
it's too much trouble to start it again.
Yeah. They only have 6 months from, there's a lot of sort of little time limits, but you have 6 months from bankruptcy notice being issued to give it to the debtor, and then you have 6 months from the act of bankruptcy to file a petition, and then the court has to make a decision within 12 months. So if you can get those, if you can make sure that it's been more than 6 months since your act of bankruptcy, they have to get a new act of bankruptcy to happen.
Okay. All right. Well, and then keep those questions coming in, guys. Well, another one that I get a lot of questions about is, can I get rid of my tax debt? Can I get rid of my child support debt? And yeah, took the words right out of my mouth. And can I get rid of my spur debt? So, that question's come through as well. So let's explore that. Let's start with spur because that's probably the most common. Does spur disappear on bankruptcy?
I've always thought no.
That's my understanding too.
What about those, so I've seen a few spur orders where it's a restitution order that was made against, say, cash converters for theft, or where it's a court-ordered debt against a private company that then goes to spur.
And
am I making it too complicated?
That's a question that my answer to that is, well, it's with spur. Spur I liken to a bit of an all-powerful being. While something's with spur, it generally doesn't disappear in a hurry.
Yeah.
So I would err on the side there of assuming spur debts are always likely to still exist at the end of the bankruptcy. Tax office, a little different, but same sort of idea. Is that your understanding?
Well, the ATO takes a lot of people to court and makes them bankrupt. So I always assumed that their debts were provable in bankruptcy.
Yes. And so that means you can get rid of them at the end of the bankruptcy?
Yeah.
And that includes, because they often charge a lot of penalties as well. That's the killer.
Yeah.
And that's likely to mean the penalties disappear as well. Child support, yeah, good luck is the short answer. They're still going to be live at the end of the bankruptcy. And look, I think that's fair enough if we're honest, because let's remember what child support debts are about. They're about orders that have been made to assist families with their kids.
Yeah.
So I think it's fair enough that they're still alive. It's a separate question at the end of the bankruptcy whether somebody's earning enough money to pay them. Entirely separate question. But in terms of I think a public policy type idea, I think that's a really important thing for people to still be understanding and still be engaging with. Now, another question that's come through, excuse me, and that's around around the voluntary bankruptcy, and we covered this a little bit earlier. We're seeing a little bit up north people who are having difficulty paying their mortgage, have tried a year to sell it, and in plenty of parts in North Queensland, properties just aren't selling. Somebody said to me that I spoke to in a small town probably about 3 weeks ago, said to me, yeah, we've had one property sold since August. People can't afford the mortgage and to pay rent.
And even if the house was sold, it wouldn't pay off the mortgage because of property prices.
Anyway, so they're feeling like they're in a bit of limbo because the banks also realise they can't sell a house if they take it.
Yeah.
And so nothing's happening. And
So
people are going bankrupt there.
And people on fairly good incomes, I find, yeah.
And is that a good idea? Well, does it solve the problem, I guess is the first question. The answer is probably not.
Well, the debt's not crystallised at that
point. So it might not lead to the trustee selling it either, might it?
Yeah.
So you might be going bankrupt because you can't pay the mortgage, but the trustee can't actually further that anyway.
And it's important to know that even though a property automatically becomes the trustee's property, as it were, upon bankruptcy, when a bankruptcy ends, which is generally after 3 years, the opposite isn't an automatic thing, as in the property doesn't automatically go back to the debtor. A trustee really can retain ownership forever under the Act.
And so once you've gone and put that property in a sense out of your hands, there's no guarantee of it coming back again. And there's also no guarantee of the problem being solved.
Yeah.
And it's a problem, and look, I'll be honest, it's a problem I know we're aware of, the banks are aware of. I know the financial counsellors listening in are aware of it too, because I've been chatting to you guys about it. And it's a problem we're going to have to confront. And I'm not certain there's a nice clean answer to it, because the problem we've got in that scenario is ultimately people owe the bank the money. And the only way they have of realising it is to sell the asset. But if we can't sell the asset and nobody can sell the asset, you're in a bit of a limbo problem. And
it might be better to wait for the bank to take the action.
To take the action because of those really serious consequences to bankruptcy that we discussed earlier. Because let's be honest, even once you're out of the bankruptcy,
still gonna
those consequences arguably still follow you around. So I think it's a really big thing to make that decision to go bankrupt. And it's a really big thing where, particularly where you've got an asset that at some stage might be realisable outside of the bankruptcy.
Another question is about court proceedings and what powers a bankrupt has while they're bankrupt to action or take court proceedings. I see this fairly often, maybe because of my line of work in the self-rep service, but we often have clients who are being forced into bankruptcy while they've got other proceedings on foot in another court. And that's a tactical thing that creditors do, because one of the effects of bankruptcy is that any proceedings on foot either against or by the bankrupt are automatically put on hold or stayed, it's called, until the trustee makes a decision about whether they, as the person there to make financial decisions, decide whether they want to continue it. And often a trustee will say no, because it's too expensive to run litigation effectively. There's no benefit for the creditors, unless it's a really strong case. So you might have clients who approach you and they might have proceedings on foot and they're really keen to continue those, but the creditor's making them bankrupt, really to try and put that on hold. That in itself can be a defence to a creditor's petition because it's what's called an abusive process. So there are options. There's also some exclusions to that. So personal injury proceedings or something, the way I like to think of it, it's something about the person, their private body, as it were, as opposed to their financial situation. Those types of decisions and court proceedings stay with the bankrupt to decide whether to pursue or not.
Okay. All right. And I think if there's any just final quick last questions, we've probably got time for maybe one or two more. So we'll just give people a minute to ask any further questions that they might have. What I would say though is if there's stuff we haven't covered in this webinar that you've really got a burning desire to know about, at the survey at the end, which Catherine's going to tell you about in a couple of minutes, please put those in the comments. Please also let us know about what you think's worked well in the seminar, what hasn't, because we're always keen to deliver stuff that's going to be of benefit to everybody out there. Likewise, if you've got any other ideas that you want to talk to us about, we're all ears. You have our direct contact numbers, so we would both welcome any inquiries you've got because our interest is in getting the knowledge about this sort of area more widely spread than it is because it is a difficult area. But as it's looking like there's no further questions, I think I'll hand over to Catherine to do the tidy up. Thank you very much for your attendance today and we'll welcome any feedback you've got.
Thank you, everybody. Just like to quickly thank Paul and Elizabeth for doing this webinar today. It's been great to have QPILCH on board to be a part of this and have QPILCH and Legal Aid together to present more information to you about the basic laws of bankruptcy. And as Paul was saying, we are running a survey at the end, so if you could please fill that out. If you have any suggestions for future topics, we will be running more webinars, so we would really love to hear your thoughts on that. And for anyone who missed it at the beginning, there are 2 handouts that you can download. So in the toolbar on the right-hand side, if you expand that out, you'll see the PowerPoint slides are there, and you'll also see the handout at the top there. Thank you very much, everyone, and we'll see you next time.